Recently, we went through what happens during a DUI arrest. This video addresses what can happen after the arrest. We left off with our motorist either having taken or refusing the test. As a reminder, for the first offender, if the motorist refuses the test, his license will be suspended for 1 year. If the motorist submits a sample over 0.08, the suspension is for 6 months. This is called the statutory summary suspension. I have been asked on more than one occasion, don't they care that I have to drive, or what am I supposed to do? Now, the short answer that you'll get from the prosecutor or from the Secretary of State is no. They are more concerned with highway safety, and you should have thought of that before you drove impaired. However, for the first offender, driving relief is available. About 2 to 3 weeks after the officer sends in your information to the Secretary of State concerning your arrest, you should receive some paperwork from them concerning the application process for a monitoring device driving permit, otherwise known as an MDDP. With the MDDP, you will have to have a breath alcohol ignition interlock device installed into your vehicle. It's also called a BAID. Now, an interesting aside about the BAID device and the MDDP is, regardless of the type of DUI the motorist receives, he has to have this device in his car. In other words, if it is a DUI related to marijuana, prescription drugs, methamphetamine, cocaine, anything along those lines, even if there's no alcohol detected, they will still have to have the BAID device in order to legally operate with the MDDP. Now, the court system is not involved in this process at all. All the motorist has to do is to complete the paperwork and send it in. There are some financial obligations, including a monthly fee to the Secretary of State. The permit allows the motorist to drive anywhere legally, as opposed to the restricted driving permit, which is something available to a motorist who has been convicted of DUI. The restricted driving permit only allows travel to work, school, treatment, and a few other exceptions. But again, getting an RDP is no guarantee. A motorist can fight the statutory summary suspension by filing a petition to rescind within 90 days after the notice of suspension has been filed. A hearing on the petition to rescind must be heard within 30 days. There are limited reasons to rescind the statutory summary suspension, and "but I need a license" is not one of them. If you or someone you know finds yourself in this situation, you need legal representation. Call me, Duane Deters, at 217-235-1647 to schedule your appointment today.